Good afternoon, everyone. Welcome to another episode of our After School Special, our weekly webinar series highlighting topics related to special education. My name is Heather Edwards. I'm an attorney with Edwards, Stevens & Tucker, and in partnership with the El Dorado SELPA, we are bringing you these weekly topics. Thanks so much for joining us today to talk a little bit about Section 504. As many of you probably know, we could probably do an entire day of training on Section 504, and I'm just going to hit a few highlights for you in the next 30 minutes. And if you have questions, please feel free to put them in the Q&A section of the Zoom, and we'll make sure at the end of the presentation that we get any questions that you may have. And there's also a link to the presentation in the chat. If you want to access the slides. So let's get started. So to start off in terms of the some of the background of Section 504, the actual statute itself, which is a federal statute, is very short. This is really all the statute says related to what Section 504 does or doesn't do. The statute says that no otherwise qualified individual with handicaps in the United States shall solely by reason of his or her handicap be excluded from the participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance. So that is how Section 504 becomes applicable to school agencies, is because almost all school agencies here in California receive some form of federal financial assistance. And so this is also why Section 504 applies to post-secondary, public post-secondary institutions and even potentially private schools if they receive any federal financial assistance in any way. But as you'll see, it is a civil rights statute. It was enacted back in the early 70s, right on the heels of Brown versus Board of Education and the civil rights movement. And it was really designed as one of the first, even before IDEA came into being in 1975, is really one of the first statutes where Congress decided to provide some equal protection for people with disabilities under the law. Next slide, please. So we know that Section 504 prohibits discrimination against people with disabilities, but it doesn't really go into a lot of detail about how we do that. It's very different than IDEA in that regard. So practical implementation of Section 504 is a little bit more difficult because we don't have that same level of detail that we have in IDEA, where it's very specific about who has to be at IEP team meetings and the timelines and all of the procedural safeguards that are associated with IDEA. We only have those few words of the statute, and then we have some regulations that have come along for Section 504 since that time. In fact, the statute doesn't even use the word Section 504 plan. So that is something that school agencies have come up with over the years as a practical way to try to implement the obligations that we have under Section 504, is to offer appropriate programs and services designed to ensure students with disabilities have equal access to educational programs, just as their non-disabled peers do. So because of that, LEAs have to really rely on very strong internal policies and procedures and understand and apply best practices in the area of Section 504. So one thing I would encourage you to do is take a look at your local Section 504 policies and procedures that you might have in place. If you have forms available for your LEA regarding, evaluations and how do we do those. We should have at every LEA a coordinator that is assigned to every LEA that's responsible for Section 504 compliance, and making sure that you're familiar with your own internal policies and procedures related to Section 504. Next slide, please. So we know that under Section 504, it requires local educational agencies to provide a free, appropriate public education to each qualified person with a disability who is within the LEA's jurisdiction, regardless of the nature or severity of the person's disability. Next slide, please. And what that means under Section 504 is that an appropriate education is the provision of regular or special education and related aids and services that are designed to meet the individual educational needs of disabled persons as adequately as non-disabled persons are met, and based upon adherence of certain procedures that we define in our local policies and procedures. So you see that standard for FAPE is not a standard as compared to an individual, but more compared to non-disabled peers. That is a very different FAPE standard than what we have under IDEA and special education law. Next slide, please. So again, unlike IDEA, Section 504 statute and their implementing regulations don't provide specific examples for what are these related aids and services under Section 504. We just know that they have to be provided to the extent that allow the LEA to meet the needs of students who qualify as an individual with a disability under Section 504 as adequately as it meets the needs of non-disabled students. So it might include things like counseling services or occupational therapy or behavior services or interpreting services. So if you have a student who may need sign language interpretation, even one-to-one aids could be related aids and services if those are the kinds of aids and services that might be necessary to meet the needs of students with disabilities as adequately as it meets the needs of non-disabled students. Next slide, please. So again, that primary difference in the standards of FAPE under IDEA and 504 is what's the type of educational benefit that's required. Under IDEA, it is more of that individual standard where we focus on an individual student's progress in relation to their own skills and deficits. We want to see growth in terms of progress from that student from, year over year. Whereas Section 504 is this comparative standard where we focus on whether students are receiving educational services that are as effective as those that are made available to non-disabled peers. Next slide, please. So one of the things that I like to start out with when we talk about Section 504 is to recognize that not all Section 504 students also would qualify under IDEA, but all students who qualify under IDEA are also protected under Section 504. So if you see these concentric circles here on the screen, and that middle circle would represent all of the students who are eligible under one of the 13 categories of eligibility under IDEA. So there's very specific requirements for students to meet in order to meet criteria for an IEP. And then those students are also covered as students with disabilities under Section 504. So any student who is eligible for an IEP is also protected from disability discrimination under Section 504. That doesn't necessarily mean you have to have both a 504 and an IEP, because one way of meeting all of the requirements of Section 504 for students who have IEPs is to have an IEP. But it also means that if you are a student with a disability, you may not meet the criteria under one of the 13 categories of IDEA, but you may still be considered a student with a disability under Section 504 and be entitled to certain protections and maybe be entitled to certain accommodations to have equal access to your programs. And we'll talk a little bit more about that. Next slide, please.
And Heather, just a brief interruption. If you can start the closed captioning on your end, that would be great.
Oh, so it only works on PowerPoint, I think. We'll try it. Okay, I just turned it on. Is that working now?
Yep, you're good to go. Thank you.
Okay, great. Thank you. Sorry. I think we usually do it a different way, but that'll work for this one. Perfect. Okay, so in terms of the remedies that are available to individuals where there's been a violation of Section 504, usually remedies are very similar to what's available under IDEA. So if there's been a violation of 504 and there has been disability discrimination, courts may authorize remedies just like IDEA, things like compensatory education services or reimbursement for private services that a parent may have gone out to get on their own and be reimbursed for those services, or even assessments, those kinds of things. The primary difference between remedies under IDEA and 504 is that there are monetary damages available for a denial of FAPE under Section 504. And so that is one of the key differences, is that parents can actually sue under Section 504 and obtain money for any damages that may have resulted because of their student who had been discriminated against under Section 504. That is not available under IDEA. Next slide, please. So one of the first things that we have to understand is, well, how does a student meet eligibility for Section 504? And so we have to know how do you define who is an individual with a disability under Section 504? And you really have two questions that you have to answer. One, does the student have a physical or mental impairment? And we'll talk about that in just a little bit more detail in a second. And second, does that physical or mental impairment substantially limit one or more major life activities? That's it. Those are the two questions to answer. And if you have a yes to both of those questions, then the student would be considered a student who is a student with a disability under Section 504. Next slide, please. So the Section 504 regulations do give us some examples of the kinds of physical or mental impairments that may be considered. Although this is a list that is a non-exhaustive list, it says such as. So just because it's not listed here doesn't necessarily mean that it wouldn't be considered a physical or mental impairment that a student may have that may substantially limit one or more major life activities. So they list things here such as, cardiovascular, digestive, compromised situations, endocrine system, any mental or psychological disorder, including intellectual disabilities, or even emotional or mental illness. And they actually talk about specific learning disabilities in terms of Section 504, which we know that we often talk about those when we're talking about special education for IDEA, but here recognize that that may also mean that the student is qualified under Section 504 as a student with a disability if they have a specific learning disability. Next slide, please. It also includes, but is not limited to, various types of diseases and conditions, various impairments like hearing impairment, visual impairments, cancer, that is considered a physical impairment, things like dyslexia, which, we talked about specific learning disabilities. So they give some examples again, but it's an includes and not limited to type of a list of the types of impairments that may be considered a physical or mental impairment under Section 504. Next slide, please. So then you have to figure out, if there is a physical or mental impairment, does it substantially limit a major life activity? And back in about 2008, there were some changes to the law that really changed the coverage of an individual with a disability and was really supposed to be construed very broadly. That substantially limits should be construed broadly and should be interpreted in favor of very broad and expansive coverage of individuals with disabilities. And they talk about how assessing whether or not an individual is substantially limited by a physical or mental impairment should be a relatively quick analysis. It shouldn't take a whole bunch of in-depth testing and things like that to know whether or not there's a substantial limitation, remembering that Congress has said it's more in favor that the student may be substantially limited, and it is intended to have very broad coverage. Next slide, please. Then we look at the list of major life activities that may be substantially limited by a student's physical or mental impairment. And it's a whole bunch of different kinds of activities. One of the pitfalls that our schools fall into is they focus in on this one that I highlighted here related to learning. And they may say, you know what, the student has, let's say ADHD, for example, which is one of those physical impairments that was listed, or mental impairments that was listed previously, and whether or not it substantially limits a major life activity. And a lot of times our schools focus on this one here related to learning. And they say, well, but the student's doing great. They're getting good grades. They're, turning things in on time. So we don't think that they actually qualify under Section 504 because they don't have, it's not a substantial limitation on learning. But I want you to notice all of these other major life activities that are listed, right? It's very different from IDEA, where we have to show some sort of adverse effect on a student's educational performance. For almost every one of the 13 categories, we have to find how is it impacting the student's educational performance in order to determine eligibility. That's not the case with Section 504. So for example, if we have a student with ADHD, and if it substantially limits their ability to concentrate, that's enough, right? It doesn't matter whether or not they actually have any adverse impact or substantial limitation to learning, but all of these are considered major life activities. It's the same reason why it may be, for example, a student with diabetes may be considered a student with a disability under Section 504, because we're not just focused on learning, we're also, in terms of looking at what is the substantial limitation for any of these other types of major life activities. And eating is a major life activity for a student with diabetes that will be substantially limited, because you have to really watch, what in terms of your intake and that sort of thing, and your ability to process. So they also list operations of major bodily functions, which I have listed there for you as all major life activities, from brain functions to endocrine functions to your bladder functions. Those all are considered major bodily functions that may be substantially limited. Next slide. When you're looking at whether or not a student is substantially limited in a major life activity, we can't take into account any mitigating measures. And so this was a significant change in the law, again, back in around 2008, when a bunch of changes were made in this area. So whether or not an impairment substantially limits a major life activity is supposed to be determined without reference to the ameliorative effects of mitigating measures, except for eyeglasses and contact lenses. Next slide, please. So those are the kinds of things like medication, for example, or the use of assistive technology, or various other types of accommodation or auxiliary aids and services. So for example, if you have a student with ADHD, if they are substantially limited in one or more major life activities, you can't take into account, if that student is currently on medication, whether or not the student is eligible under Section 504. So you are not allowed anymore to take that into account for eligibility purposes. Next slide, please. So you would not consider the effects of mitigating measures in determining eligibility. That doesn't necessarily mean that we're suggesting, for example, for a student who's medicated by their parents in accordance with doctor's orders. We're not saying to ask the parent to stop medication or anything like that while we are determining eligibility, but you want to focus your evaluation on the student in an unmitigated state. So you may want to do that by reviewing records to determine the student's performance without those mitigating measures. Talk to the student's teachers and school staff, maybe even prior to starting medication. Try to get consent to exchange information with medical or mental health professionals that the parents may have, to try to understand how does the student's physical or mental impairment impact their major life activities when they aren't medicated or in some other sort of mitigated state, and interview parents. So we want to try to gather as much information as we can on determining eligibility without, again, it having to be a very extensive analysis. So we wouldn't consider it for determining eligibility, but we will consider mitigating measures when we're looking at whether or not any 504 accommodations are required for the student to have equal access to their program. So again, those mitigating measures, like a student being medicated, may be effective in reducing or eliminating the negative effects of the impairment. So that is why we may have students who we call technically eligible under Section 504, but that they don't actually require any 504 related aids and services or accommodations. So that means they are eligible because they meet the definition, but no Section 504 plan accommodations would be necessary. So that means that those students still have protections under Section 504 as a student with a disability. So they are, insured to continue to have reevaluations. All of the disciplinary protections of manifestation determinations would apply. They still have due process rights for these technically eligible students. Next slide, please. So again, let me just reiterate that. It is possible for a student to be eligible under Section 504, but not require an IEP and not require a 504 plan. They're still going to be entitled to all of the protections from disability discrimination that are afforded by Section 504. Next slide, please. So an example of a technically eligible student, this came from the Office of Civil Rights back in 2012 in a Dear Colleague letter trying to help schools understand this distinction. So let's say you have a student who's diagnosed with severe asthma. That is considered a disability under Section 504 because it is a physical impairment that substantially limits the major life activity of breathing. And it is a function of the respiratory system, which is a major bodily function, right? So boom, students eligible, very easy, cut and dry analysis. However, based on the evaluation that the team did, the student doesn't need any special education or related services as a result of that disability. The student fully participates in the school's regular PE program, in extracurricular sports, doesn't need any help administering medicine, doesn't require any modifications to the school's policies, practices, or procedures. So the LEA is not obligated in this case to provide the student with any additional services, but they remain protected by the general non-discrimination provisions of Section 504 and the ADA. So it's really important for your teams to understand those distinctions and to have a good way to track those students who may be technically eligible under Section 504 because of the definition of an individual with a disability, but that they don't actually require any accommodations. Because if that student gets in trouble and they are, for example, they may be up for expulsion for some reason, even though they may not require any accommodations, we still need to make sure that we go through all of the manifestation determination protections that a student under Section 504 would be entitled to. Next slide, please. Another issue that comes up is whether or not a student with a temporary disability would be considered an individual with a disability. And it is very much a lawyerly answer of it depends. So what the regulations have talked about is that a temporary impairment does not constitute a disability unless its severity is such that it results in a substantial limitation of one or more major life activities for an extended period of time. Again, this is one of those areas where they don't really tell us what is an extended period of time. So the issue of whether a temporary impairment is substantial enough to be a disability has to be resolved on a case-by-case basis, and you have to take into account the duration or expected duration of the impairment and to what extent does it actually limit a major life activity of the affected individual. Next slide, please. Again, there isn't a specific rule about what constitutes an extended period of time that would consider something to be a temporary impairment that qualifies as a disability. OCR has said that the interpretation of an extended period of time shouldn't really contravene the standard under Section 504 for reasonableness, right? So what's reasonable and shouldn't be interpreted rigidly. So it does give, some discretion there about what is considered an extended period of time for a temporary disability to count as a Section 504 disability. Next slide, please. This also comes up for those types of impairments that may be episodic or at certain times may be in remission. So an impairment like cancer, for example, that may go into remission at certain times is considered a disability if it would substantially limit a major life activity when active. So those are, that's the guidance that we've received from the Section 504 regulations on that topic. There is also a child find obligation under Section 504. So we know for IDEA that we can't take a passive approach in terms of LEAs going out and finding students who have disabilities, and 504 is no different. So schools are required to undertake to identify and locate every qualified person with a disability residing within your jurisdiction who is not receiving a public education. And those students who, because of handicap, need or are believed to need special education or related services. So again, that obligation to refer a student for a Section 504 evaluation may be triggered, even if the parent doesn't request such an evaluation or request any sort of accommodations, if the school has been put on some sort of notice that the student may have some sort of a disability. Next slide, please. So if the LEA doesn't have any reasonable basis for suspecting that the student has a disability, you may refuse to conduct such an evaluation and provide notice to parents of that decision. Just keep in mind that the threshold for referring a student for an evaluation is a lot lower than the eligibility threshold. So again, that's very similar to IDEA, that it's not whether or not we think the student is going to qualify, it's just whether or not we think that they might qualify. And that is enough for us to have a suspected disability to offer to do an evaluation. Next slide, please. So the Office for Civil Rights has determined that parental consent for an evaluation under Section 504 is required because parental discretion is an appropriate and necessary policy component at that initial evaluation stage. So you should have forms and procedures for getting parental consent for that initial evaluation under Section 504. And then if a parent refuses consent for that evaluation, the LEA won't be liable for a child violation under Section 504. But again, just like with assessment plans for students who have a suspected disability under IDEA, we would want to document that we actually sent a consent for an evaluation under Section 504 to the parents and make sure the parents received it. And then it's really up to them whether or not they are in agreement to pursue that evaluation or not. In terms of what does the evaluation look like under Section 504, because I know we use that term a lot with special education, the main components of a 504 evaluation is that a team draws upon information from a variety of sources. So that could be information from teachers, information from parents, information from doctors, various tests, various medical reports, and to document and consider all pertinent information, report card information, medical diagnoses, all of that information needs to be considered. And that is really what an evaluation under Section 504 is. It doesn't necessarily have to be a very in-depth analysis, but again, considering relevant information. And who does that? It has to be a group of people. So one person wouldn't be enough, right? A group of people, including those who are knowledgeable about the child, the disabling condition, the meaning of the evaluation data, and the placement options in that in the placement decision. If you are going to do any testing, you would have to make sure that they are appropriate assessments, that sort of thing. You're not required to do formalized testing necessarily. You can go to the next slide, Kathy. Thank you. You're not required to do any formalized testing unless the team, that 504 team, determines that it's necessary. So know that an evaluation does not necessarily mean test, right? It's just to draw information from a variety of sources. And you may have sufficient information without conducting, standardized testing, that sort of thing. You may have RTI data, you have report cards, you've got curriculum-based measurements that you can use that may be sufficient to determine eligibility for a student. Next slide, please. What are the timelines for these evaluations under Section 504? Must be conducted within a reasonable period of time. So the Office for Civil Rights has found that delays of several months are typically going to be unreasonable. But a lot of times throughout Section 504 regulations, when you don't have a specific timeline that we might have in IDEA, with this reasonable period of time, usually the Office of Civil Rights, when there is some sort of an allegation, they will look to IDEA as sort of a guidepost. So if we know that an evaluation has to be conducted within 60 days of parental consent under IDEA, that gives you kind of a good general timeline to follow under Section 504, because they always at OCR rely on, well, what are they doing over there with IDEA? And that must be about a reasonable time frame under 504. And then the law also, go back just one second, the law also requires us to reevaluate periodically and prior to any significant change of placement. So periodically, again, that is not a hard and fast rule, but if you use IDEA's triennial review process as a guidepost, or more frequently, if the conditions require you to do it more frequently than every 3 years, that would be a good rule of thumb. And again, any significant change of placement would likely be anytime you're looking at discipline for more than 10 school days in a school year, transferring student to another program, or terminating or significantly reducing the services that the student might be receiving. Those are all going to be considered a change of placement that would require a reevaluation. Next slide. So the law, again, doesn't specify any specific timelines, but plans do need to be reviewed on a yearly basis. That is really best practice. Again, using IDEA as a guidepost where they do annual reviews of IEPs. And it does need to be in a meeting, that a meeting should be convened to review the student's progress, make recommendations to continue, modify, or terminate the program. Also, when a student is moving to another school level, so maybe from elementary to middle school or middle to high school, that new school should review the plan and make adjustments to the plan to reflect the student's, new class schedule, new program, new demands, what kinds of appropriate accommodations may be necessary. Next slide, please. The other thing that sometimes people ask about is, what about those students with health plans? So the Office of Civil Rights has held that the practice of providing a healthcare plan to a student, for example, who has diabetes or asthma or food allergies or other health-related issues, instead of actually going through the procedures of determining eligibility under Section 504, would be considered a violation of Section 504. So just because a specific student's health needs can be accommodated with a health plan, it doesn't necessarily relieve you from your obligation to create that 504 procedural documentation of documenting that you did an evaluation, that you got consent for the evaluation, that you've documented eligibility under Section 504. So if you have a student with a severe peanut allergy, that it's documented clearly that they're eligible under Section 504 and they're entitled to all of those protections of a student with a disability. So the key here is, whatever you call the health plan, an individual health care plan, whatever you call it, regardless of what you call it, you have to make sure it was developed in accordance with the procedures that satisfy all of these procedural requirements under Section 504. Next slide, please. So as we talked about, you have to have a meeting of a group of people knowledgeable about the student and the student's disability and their academic needs once that evaluation is complete, which typically is going to include, relevant school staff, students' parents, any assessors, or anyone that the parents may want to bring. And then you determine whether or not any accommodations are necessary, and that would allow the student to have equal access to their educational or non-academic activities. And parents may request particular accommodations, but ultimately those accommodations are determined by the 504 team. And then the parent certainly has recourse if there's disagreement about what is considered an appropriate accommodation. Next slide, please. So a few best practices for drafting those accommodation plans is to really try to avoid ambiguity. So think about, when are these accommodations needed? Anytime, or only in certain classes, or only certain times of the year, or only during transitions? Really try to be specific about when and where and how those accommodations are needed. Really try to get away from using language like as needed. The student can have extra time on assignments as needed, because the problem with that is it's an implementation nightmare. Who decides when an accommodation is needed? That is really the job of the 504 team to figure out, based on the evaluation information, when is it needed, right? And let's document that in the 504 plan. And if it changes, you can always revise the 504 plan accordingly, but making sure that you get as specific as possible, because those terms can be interpreted differently by different people. And we need to explain what was intended to avoid conflict later on down the road. Next slide, please. Think about what kinds of activities are going to be coming up for the student in the particular year, and whether or not there are certain accommodations that might be appropriate and necessary because of what's going on that year. Fourth grade, we're doing the mission report, and these are the kinds of accommodations that the student might need for a large project like that. And is it appropriate for that student at that grade and age level? And then consult with the students' teachers before the meeting, so you have some idea of what accommodations were working, what wasn't working, what's no longer necessary for the student, and making it very clear in your plans whether or not the accommodation is a choice that or that the student has a choice. For example, if they want to take tests in a separate setting, or if it's a requirement, because that comes up quite often in terms of implementing those plans. Well, it was offered, but the student never took advantage of it. So we want to make it very clear. Is this something where the student can decide whether or not in the moment they want to access that accommodation, or is this a requirement that we want to make sure we're implementing? Next slide, please. Be very cautious with those checklist style accommodation forms, because a lot of times with those, school staff members will just start checking off everything that they think might be a good idea. These might be things that would be helpful to the student. And again, our job is to really determine what's required, not just what's desired. What is required for this student to have equal access to their educational program? Because then once we put that in there, we have to make sure that we're implementing it. And we also want to be thinking about that we want to provide support, but also foster independence of students with disabilities. And we don't want to provide them so much support that they're not able to act independently, and to make sure that they are really individualized for each individual student. Next slide, please. So in terms of implementation, you want to make sure that the school staff makes the necessary accommodations to allow for the student's disability. This can be a challenge sometimes in certain classes, maybe advanced courses or honors classes, where it appears that it's some sort of an unfair advantage to a student with a disability. So we really want to make sure our staff understand, not only is this a legal requirement, but that this is to ensure that the student has equal access to this program. That's really the whole idea behind Section 504. Parents should be consulted and give opportunities for input. And then the accommodations are implemented. And we want to, again, try to not wait for the student to request them. That we really want to make sure that if the student's not accessing them, then maybe it's time to get back into a 504 meeting and talk about why is that. Maybe we need to accommodate in a different way if the student's refusing a particular accommodation. Next slide, please. So really take time to introduce accommodations plans to your teachers, explain how the students, what the student's disability is and how it impacts them in the classroom, explain why certain accommodations were selected and how those accommodations need to be provided. So you want to really provide support to your team who has to implement these accommodations so that we can ensure compliance to make sure that they're actually happening, that they understand why they're happening and how they can help support the student. And maybe they need some support to actually how they actually will deliver those. And then make sure that the accommodations are being implemented. Anticipate that you may have some teachers who will refuse to implement certain accommodations. So we've certainly had that situation come up where, surprise, we just learned, a year into the school year that a particular teacher hadn't been allowing a student to use certain accommodations. And so we want to know as soon as possible if that's not happening, and then address it with our staff as soon as possible. Next slide, please. So as I mentioned, there is a manifestation determination like process under Section 504. So the reason that happens is Section 504 says that you must evaluate a student before making any significant changes in placement. And so the Office for Civil Rights has interpreted that guidance to mean that there needs to be a manifestation determination like process anytime you are looking at removal of a student for more than 10 school days in a school year. Next slide, please. So again, you would want to look at, similar to our students with IEPs, holding a manifestation determination for students eligible under Section 504 to determine whether the student's conduct was related to the disability or if it was caused by the LEA's failure to appropriately implement the Section 504 plan. And we have to base that information on whatever competent information, such as psychological data, that sort of thing that we may have, any information recent enough to give understanding of the student's current behavior. Next slide, please. And then, similar with our students with IEPs, if it's determined that the disability is the cause of the misconduct or the district did not implement the 504 plan, then we cannot suspend for more than 10 consecutive school days. Instead, we would need to look at modifications to the program or some sort of alternative placement. But if it's determined that the disability was not the cause of the misconduct, then you can move forward and suspend or expel, just like any other student, non-disabled student. So that is the idea with manifestations. In terms of your procedural safeguards for Section 504 students, you need to, at a minimum, have in those policies and procedures notice of your Section 504 discrimination policies and rights, an opportunity for parents to review relevant records, an opportunity for an impartial hearing with an opportunity for participation by the student's parents or guardian or represented by counsel. So this comes as kind of a surprise to some of the schools that we work with, that there is actually something called a Section 504 hearing. So it doesn't come up very often, but if you have a parent who has gone through your internal grievance process that you likely have for Section 504, and ultimately you can't reach an agreement, there is a process where they can go through an impartial hearing, where you will have to find an impartial hearing officer to hear the parents' complaints related to Section 504. More often what we see with complaints is that parents will file with the Office for Civil Rights that there's been some sort of violation of Section 504. That's typically what we see. But as I mentioned earlier, you do have to make sure you have an employee that's designated as responsible for Section 504 compliance. That should be listed in your procedures, who that is and how the parent would go about contacting that person. You have to have public notice of your non-discrimination policy and then a review procedure. Again, compliance with IDEA due process procedures is one way to meet this requirement. Most schools have their own separate list of notice of procedural safeguards for parents under Section 504 that they provide. So that's all I have for you today. Here is a link to our free legal alerts on our website if you're interested, and we will go ahead and take any questions that you might have after we stop the recording. Thanks.